by the rules to you. You have 15 minutes. You know, if I didn't give Patricia more than 15, you're not likely to get more than 15.
Thank you very much, Mr. Chairman. I think that I'm very fortunate. I think I can get the message that I've been asked to bring to this panel. I think I can get it over in less than 15 minutes, simply because the distinguished chair and two members of the state legislature from the state of Alabama happen to be on the panel. They are probably more familiar than I am with the individual that I've been asked to come here on behalf of. I want to first say thanks to the Schiller Institute for inviting us here to testify before this very distinguished panel. We had an opportunity some 6 weeks ago to have our initial encounter with the members of the Schiller Institute when we participated in a lobbying session with them on the Hill, solely for the purpose of trying to get the Judiciary Committee to include the LaRouche case as well as the selective prosecution case of black elected officials in their hearing on the Waco incident. We were not able to get this done. However, I'm convinced that most of the people that we talked to on the Hill realized that the problems that we brought or what we wanted them to go into, I'm convinced that they were sympathetic. I'm convinced that they knew what we were talking about. So again, I want to say to the Schiller Institute, I want to thank you for giving this group of people that appeared before me an opportunity to bring their individual cases before this very sensitive. I can just look at that panel and I can tell how sensitive they are to the problems that have been encountered by my fellow men and women here that came before me. I come to you with a very limited political background. I spent some 32 years in federal service where I had the restrictions of the Hatch Act. Being a nonpartisan observer of political activities primarily within the state of Alabama. After having graduated from Morehouse College in 1949, being a classmate with Martin Luther King, who really led the revolution of our people. The next 10 years, after 32 years, was spent as an elected official, as a council person with the city of Birmingham. There I had an opportunity for the last 10 years to work very closely with Mayor Richard Arrington, Jr., whom Representative Clark, Representative Hilliard, and the Honorable Gerald Chestnut probably know much better than I do. I want to say here that the record will show that for the last 20 years, Richard Arrington Jr. has been a constant target for prosecution. I happen to believe that much of that prosecution probably was at the hand of our government. I heard the statement today for the first time that I love my country, but I fear my government. I'm afraid I'm going to have to subscribe to that statement. Even though I personally have been able to withstand the wrath, if you please, of my government that presented itself 10 years ago with the firing of a son, that came back 10 years later with the firing of that same son by the same folks for different reasons. And after having worked for the federal government for 32 years, I was audited on one occasion for income tax. After being elected in 1985, I personally was audited from 1985 until 1992, each year. So I can kind of sympathize with Representative Clark and Representative Hilliard down in Montgomery, who may have been audited in that most recent audit on the state of Alabama. If they was not audited this year, they'll probably be audited next year. Okay? So I think the trials of Richard Arrington Jr. is ongoing. We just came out of court last week, and I think at that court case we lost. We lost the first case that we've ever lost with being represented by Attorney Watkins, who is well known in the state of Alabama, and that was on a bid for a communication system somewhere in the range of $11 million, whereby the state Supreme Court ruled that we had not violated the state bid law in issuing the contract to Motorola Corporation to build the system for us. The federal court intervened with a jury trial that found that even though we may not have violated the provisions of the state bid law, we did not deal properly with the consultants. So the consultant for Motorola, they felt that we favor them. And as such, the contract to build the system was thrown out of court. And the investigations are ongoing. I guess I could talk for a long time about the things that's going on in the state of Alabama that I see as an observer, not being a Republican or a Democrat, because of 32 years as a nonpartisan person. We know what's happening there on the partisan line. We know where we are now. We know that we have a Republican in the state House. We know that the majority of our representatives from the state from the Jefferson County are Republicans. We know that in a very short time, if we don't watch ourselves, the whole state of Alabama are going to be Republican. And with that, Republicans, we're going to bring on the type of things that you have here in Washington, the Newts and the Grahams and all those boys. So I'm gonna wind down now. And if anybody want to ask some questions, I guess the chairman, JL, and Representative Heath and Representative Clark and myself can probably respond to them.
When you say the whole state's going to be Republican, you talking about white folk.
White folks.
For the record, Richard Arrington is the black mayor of Birmingham, and he has been subjected to 10 years of intensive investigations by the federal government. A black woman came into my office several years ago, right in the midst of all of these investigations. Her name was Marjorie Peters. And she said that she had been a consultant, as Councilman Bell knows, and she'd been a consultant to the city of Birmingham, and that the government had found some fake invoices that she had sent to the city of Birmingham and collected the money on, and it wasn't any question that they could prove it. But they had offered her a deal that she could walk if she would bring down the black mayor of Birmingham. And for some strange reason, she came to me. I would have thought that I would have been the last person, but she did come. And I gathered from her having picked me out, she had no intentions of bringing down anybody black. So I said to her, well, we will go to trial. And there was a terrible trial there. The mayor was in contempt of court and sent to federal prison. But Marjorie Peters never cooperated with the government. J.L. Chestnut never cooperated. When I say the government, I'm talking about the Justice Department. Never cooperated with them. The end of all of that was that the government didn't even indict Mayor Arrington, much less convict him. And they had promised Marjorie Peters that she was going to do 200 years. I think that she got about 2-3 years, and that was it. But once again, it required one hell of a fight. Once again, it required that those in power understand that this is not just a fight in the courtroom. It's going to be up and down the streets of Alabama. It's going to invoke boycotts and reminiscence of the 1960s and every damn thing else we can come up with. This is not going to be a situation here where you're going to stomp on us and we're going to say, Yassa boss, no way. And that is the only way we got out of that. Except for that, Dick Arrington would be the ex-mayor of Birmingham. Anybody got some questions to my right?
Yes, sir. Thank you. Thank you, Mr. Chairman. First of all, I'd like to say, Councilman Bell, I've practically grown up in the political system all my life. Thank God for a bunch of chestnuts throughout the state of Alabama. You know, a long time ago, we would have long dissipated from the scene of politics in Alabama had it not been for people like J.L. Chestnut and yourself, Councilman. But before I even got involved in the political system, I worked for a politician. And I just remember so vividly clear one day when the FBI burst into the office with clients and customers sitting in the lobby, flashing their badges and saying that they were the FBI. And I mean, 10 or 12 came, and it was purely an intimidation technique to start rumor mills throughout the city. Before nightfall, from my barber all the way around, we were being indicted. We were either unindicted co-conspirators or any type thing that could be that was said. What I say to that is that we're gonna have to come together at some point and create some type of institute that can monitor this type of thing on a regular basis.
Yeah.
Because right now, we're not privileged to that. I mean, out of all that we have gone through in Alabama, I am in complete awe when I listen to story after story on what's happening. Pretty soon, there will be as many ex-official legislators there are sitting official legislators, African-American, which are really going through the same problem. They infiltrate our community with rumor mills, which totally destroy your credibility, your character. You know it's a problem when you go to church and after the sermon, the preacher look over and say, I hear you're gonna be indicted. What I say to you is that our community, we have to get back to the grassroots. We have to get our information out there. And there's so much more I could say, but I'm gonna leave it open for someone else to really make comments. I wanna say we need to leave here today. I've been to not like meetings. This is the first one of this kind that I've ever gone to before, but I've attended at least several meetings over the United States on talking about coming up with an agenda. I haven't seen a real agenda yet. So we got to come up with something concrete that we can float around that will be almost the biblical plan on something that we can do to solve these problems.
Thank you, Brother Hilliard. Anybody else down there? Yes, ma'am. Yes.
During the lunch break, in speaking with the ambassador here, I promised that I would ask to have someone to explain why in South Carolina and in many of the other states I've heard since I've been here too, what is plea bargaining is what they want to know and want to get it on the record.
Judge.
Well, and there may very well be someone here more in a much better position to comment on it than I, but from what I see, I don't think the traditional concept of plea bargaining is I'm sorry. If you don't mind,
all right,
I'd like
yeah,
to see it.
come on, sit right here.
I don't know that the traditional idea of plea bargaining is still so much in vogue in the federal system because they use such a steamroller technique. As I recall it in the state system, essentially, it offered a person a chance to reduce their exposure if they in fact had some degree of guilt, or if they in fact felt that the evidence was such that they might feel they weren't totally guilty, but the odds were that they might be found guilty. Then the prosecution in return might consider letting them plead to a lesser charge because the state would profit or benefit from not having to use the court's time and expenses carrying out a trial. But from what I've seen, both as an attorney and personally in the federal system, I don't know that there's much plea bargaining going on anymore. They simply tell you, you either take this or we're going to try to put you away. And I think someone made the comment earlier that they've got the public coffers at their disposal. They've got all the police agencies. They've got the media that they use, you know, in their propaganda tactics. So I don't know that the plea bargaining as we once knew of it, and in fact, I think there's been a good deal of movement, Congressman, to do away with it totally. So I hope that answers the question.
Does it, the ambassador and Mrs. LaRouche, does that, because they wanted to make sure that we got on the record.
Well, I think it would be useful for international audiences to explain what is plea bargaining, because this is not something which exists in the legal systems of Europe, for example. And also the fact that I think 98% of all cases, federal cases, end up plea bargaining, which from the European standpoint is like an inbuilt way of getting people to admit to crimes they haven't committed.
Oh, let me comment on one other aspect of it. I think, and it might have given rise to a lot of it. You would find a lot of so-called plea bargaining in jurisdictions where you had tremendous caseloads. So a lot of people, particularly when they were facing misdemeanors, if you've got someone charged with a misdemeanor and maybe they don't have the finances or the inclination to go through a trial, they're not really interested in standing on their rights, they're not so much concerned with having a criminal record. And they've got, or maybe it's even a felony, but they've got a tremendous backlog, and the solicitor says, well, listen, you can either hang tough and we'll try you for aggravated assault, which is a felony, or I'll let you plead to simple assault and battery in the magistrate's court when the maximum is 30 days or $210. A lot of people would just jump on that. And it reduces, it lets them get rid of a case real quick. It's not some high-profile case that the public is going to have some tremendous outcry about as a result of it. The prosecutor gets to put that down in the win column when he gets ready to run for public office and give you his percentage totals as to how all his cases, they never walked.
Judge, I thank you, but
Good.
I have unequivocal orders here now. We have to end this.
Great. I hope that answers.
Just one point.
Quickly.
I think that what they was talking about, Judge Ferguson, is that when you was talking about lost trust, you mentioned the fact that we tried Luther Tiller first. And as a result of him getting all these, 7 or 8 months, the rest of the guys plea bargained for 1 year. I think that's what the gentleman was talking about.
Let me see if I can flesh it out briefly.
All right.
We're talking about two types of plea bargains because we're talking about two layers of court. In the state court, plea bargain means one thing. In the federal court, plea agreement means another. Now, in the state court, and what Judge Ferguson said is true, but very briefly, I'll tell you how it comes about. I've been both a prosecutor and I tried a case last week as a defendant. So the prosecutor, for reasons of his own, will agree with the defense attorney that he will accept a plea to a lesser offense, or to 1 out of 10 cases, or, and that's one way, and then you leave the sentencing to the judge, or the prosecutor will agree that he will recommend to the judge, and this is pretty binding or you wouldn't do it, that he will recommend to the judge what your maximum sentence would be. So that's two types of plea bargaining in the state court. The prosecutor holds the key. He'll either take it to a lesser offense or to 1 out of 10 cases, or he will agree to recommend a maximum sentence or probation, as the case may be. The federal system has gone through a major change beginning November 1987, in which judges now sentence according to a chart. That chart considers criminal history. Each crime has a number, and you go across and down and you arrive at the sentence. Now, the plea agreement is entered into in nearly all cases where pleas are done with the United States Attorney. However, that plea agreement does not bind the judge. It does not even state what the sentence is going to be. It, in many cases, says what count in a 100-count indictment that you're pleading to. It may state, in some cases, a quantity of drugs or prohibitive substances that you agree to. All of those ingredients then are before the judge when he sentences you. The judge is not bound by that plea agreement. The judge, in the meantime, has received a report from the probation officer who has worked many hours on each case to determine your history and what your magic number is. And that magic number is before the judge. And he will either sentence you to that, which he does 80% of the time, or he will depart downward or upward, depending on the presentation made before him, depending on what the U.S. Attorney may agree to. But generally speaking, a federal judge will not be too much influenced by what the agreement was between the prosecutor and the defendant. He's going to go by the sentencing guideline chart, which is an insidious, horrible. I was chairman of the subcommittee on the judiciary, and I kept the guidelines from passing for 10 years. It was Teddy Kennedy's little thing. I even debated with him at New Jersey College on the subject because sentencing should be an individual thing involving all the facts, the personality, the record, and all those things, not some chart. 4 years after I left the Congress, the Guidelines Commission was instituted, and their results became effective November the 1st, 1987. Some judges even resigned as a result of it because they believed in individual sentencing. But generally speaking, it makes being a federal criminal judge a very easy job. You don't even have to have a conscience. You've got a damn chart.
I'm delighted that the congressman spoke out because he is now in charge. We thank you, Councilman Bell.
Councilman Bell, we met, right? We met? We met, we know each other, right? I think we do. Okay. Look kind of old, but I think I remember.
All right, we'll ask Odin Anderson and Mr. LaRouche and Helge if they desire to come to the table.
Whatever notes you have remaining, Debbie, you can now send them to the congressman.
Pardon? As we attempt to study the broad subject of misconduct by the Department of Justice, and we look at Ruby Ridge, and we look at Waco, and we look at Demoniac, and others of lesser notoriety, we cannot overlook the one that is perhaps the most pervasive, and I'm stealing the word from Ramsey Clark, I think, most pervasive course of misconduct by the Department of Justice in the history of this country. Broader based, long-standing, abuse of power beyond expression. Abuse of power through the use of federal agencies, including even the bankruptcy court. Throughout the days of the LaRouche ordeal of criminal charges, Odin Anderson, a lawyer from Boston, has been the solid rock of criminal defense and counsel far and above any other person. He can therefore speak to the subject of misconduct or such facets of that as he may choose to discuss better than anybody, with the possible exception of Lyndon and Helga. He has literally devoted a major portion of his life in the last 7 or 8 years to that, 8 or 9 years to that task. And we appreciate him taking the time to be here from Boston to make some such statement as he wishes to make and be responsive to questions. Thank you.
Thank you, Congressman, honorable panel. It's I who thank you for this opportunity to speak about the LaRouche case. I'm thankful as I looked up and counted names that there were only 11 of you, because if there'd been a 12th, I would have been tempted to retry this case in front of you, assured, I think, that Mr. LaRouche would finally get a fair trial. If I could add one piece to the explications of plea bargaining that have already been offered, just because there is an unseemly bottom side to the rock that I don't think has been directly addressed. It used to mean, as everyone described, the opportunity of a defendant who felt he might have exposure or at least the possibility of conviction to come to the prosecution and offer a plea in exchange for a lesser sentence. And that was the original meaning and fact of the term. And what it's come to mean, particularly with reference to the federal government, the various United States attorneys, and the Department of Justice, has been that they come to you, and as testimony from our earlier witness so horribly sums up, tell you that if you don't do something, they're going to send you to jail for 200 years. So that's become the plea bargain. You do what they tell you, or you get 200 years. That's the new meaning of the term plea bargain as defined by the Justice Department of the United States. I have represented Lyndon LaRouche since 1984, at which time he was directly targeted by the Department of Justice through its U.S. Attorney's Office in Boston. Although there is a history of many years prior to that. And why is this case of Lyndon LaRouche of interest to you busy senators and representatives of color who have very busy agendas and a lot of work to be done for your own constituencies? Because political targeting is political targeting, whether it's on the basis of race, which we see constantly and you deal with it in every day of your lives before you became elected representatives, and certainly now in a different way, or for other political reasons. Political advocacy of various kinds, if it is not of the sort that is favored and smiled upon by the federal government, becomes the object under the direction of the Justice Department of targeting and ultimately prosecution. And that's what happened in the case of Lyndon LaRouche, and it's what happened in many of the other cases, if not all of the other cases that you've been addressing this morning. Back in the late 60s, you probably all remember a student organization called the Students for Democratic Society, the SDS, very active on campuses, particularly around the Vietnam War, but on many other issues of political importance to the United States, economic, social, broad range of issues. Mr. LaRouche and a number of political associates of his became involved in those very same issues. But they had a difficulty with SDS and essentially founded their own group, which became known originally as a faction of the SDS, the labor committees, but ultimately became known as the National Caucus of Labor Committees, which was and remains a political association a voluntary political association of people who share like political views. I have probably the best way to demonstrate the government's venal behavior and the unconstitutional activities undertaken directed out of the criminal division of the Department of Justice is to show you their own documents and read to you their own words. And by way of history, I'd like to have number 1 put up on the screen. What you see before you is an FBI memorandum from the SAC, who is the special agent in charge of the New York field office of the FBI, to the director. It's dated I have a little difficulty seeing it, as I'm sure you are, but sometime in late 1969 or 1969.
March 69.
And it requests authorization of the director to issue a false leaflet to stir up antagonisms between these various aspects of SDS. Now, I'm sure that's a tactic familiar to all of you, if in slightly different form. They want to disseminate this leaflet under false cover to various of these groups and stir up as much controversy between them, there hopefully undermining their ability to act in concert and getting them into faction fights, which would destroy their efficiency and cohesion. Well, if you put up number 2, you'll see that they got that authority from the director of the FBI and his blessing. Authority is granted to anonymously mail copies of the leaflet submitted. Now, I'm not going to bother to show you the leaflet because it's a piece of scurrilous garbage. It's available for anyone who'd like to see it. It was called the Mousecrap Revolution, but its intent and purpose was exactly as defined in the letters. This is the Department of Justice. This is the FBI at work in the 1960s under, and if you look at the bottom, maybe it was on the previous document, but this was what was called, well, right, third line from the top, COINTELPRO, Counterintelligence Program. This was in place until a set of hearings, which Congressman Mann, I'm sure, remembers, that were convened in the 1970s in both the Senate and the House, which gave rise to a new set of guidelines for FBI conduct called the Levy Guidelines. Well, we got the guidelines, but the behavior didn't change. All that changed was the words. A number of other convenient avenues of similar conduct have opened for the government in the meantime, largely through executive orders issued by the presidents of the United States, which is entitled the FBI and other agencies within the intelligence community to essentially engage in any activity that they deem appropriate, so long as they can cover it with a national security cover. And we'll get into that a little bit more later. So in 1969 and 1970s, this was the kind of activity which was going on against the LaRouche political movement and many others, certain including people that you're well acquainted with personally. If we could move on to the next overlay. This is to the director, again from the SAC in New York, regarding, and the name subject, Lyndon Hermile LaRouche, Jr., also known as Lynn Marcus, as they suggest. This is the most incredible piece of FBI material, one of the most incredible pieces of FBI material that I've ever seen. And I have to stress something to you, all of you who are involved in the effort. You ask, what is our agenda? How do we fight against these wrongs, these evils emanating from the very center of our government? One of the difficulties is that you can't get the proofs. Where are the proofs? The proofs are hidden. It has taken us literally years. I appreciate the kind words but my time is de minimis compared to the time of all of the others who have contributed to the effort to bring this case to the point at which it currently exists. An unsatisfactory point, but a point nonetheless where we have established evidence which clearly demonstrates to any honest and unbiased viewer the level of government misconduct that went into this entire witch trial of Lyndon LaRouche. We're Communist Party. I'm going to get it. That's the Communist Party of the United States. What this suggests is that the Communist Party has let the FBI know that they want to eliminate Lyndon LaRouche for their political reasons. They consider him to be a politically dangerous person, and the Communist Party wants to eliminate him. If you look at the bottom, New York proposes submitting a blind memorandum to the Daily World to foster these efforts. Here's the FBI climbing in bed with the Communist Party in order to effect the elimination of Lyndon LaRouche from the political scene. I think we all know what that means. And they go on to say that it's believed that once eliminated, the political effectiveness of the National Caucus of Labor Committees will thereby be diminished and it will cease to be of any political significance. Here again is the FBI in the 70s in operation. Years went by, and the members of the National Caucus of Labor Committees continued their political efforts. Now, they are considered, Mr. LaRouche is considered extremely controversial by many. Those he's considered controversial by tend to be those whose policies are inconsistent with his, or those that he has named as being, as operating against the best interests of the society and peoples of the United States. And we all know that those people tend to be very powerful people. So moving on to a period in the 1980s after Mr. LaRouche had engaged on an actual political agenda. He ran for, as you probably know, has run for President of the United States on 4 or 5 occasions, beginning in 1976 under the umbrella of a political party founded by him, the U.S. Labor Party, and since that time as a Democrat, not always welcomed into with the warm arms of the National Democratic Committee, but a Democrat nonetheless. One could wonder whether the National Democratic Committee, whether you'd want their arms around you in the first place. But so moving into the 80s, Henry Kissinger, who we all know by name and some probably remember by reputation and actions, was a very powerful man. Mr. LaRouche took exception with his policies, which he considered to be genocidal and in social aspect and totally, particularly in context with the financial policies and the conditionalities imposed on the Third World in order to get monies from the World Bank, got into a serious row with Mr. Kissinger. And Mr. Kissinger, if you put up the next overlay, writes on his letterhead to William Webster, the director of the FBI. They had recently had a lovely social occasion together at a place called the Grove, where these powers associate and frolic around in various curious ways. And after that, he thanks, he appreciates having seen him there, and asks for the assistance of Bill Webster in dealing with the LaRouche menace. If we can go to the next overlay, in all of these documents, if you'd like to see them, I'm trying to rush a little bit because I know we're all behind, and Mr. LaRouche and Mrs. LaRouche are both here, and I'd rather have you hear from them than me. So here is, within the short period thereafter, the Buck Revell, who was the head of counterintelligence for the FBI, I believe at the time, sent this memorandum by William Webster, who was contacted by David Abshire of PIFIAB. That's the President's Foreign Intelligence Advisory Board. And these same parties, Henry Kissinger and his colleagues, are now raising before PIFIAB the question as to whether LaRouche is, because he seems to have funding from sources that they don't understand, is possibly operating as a foreign intelligence agent, and they want them to look into this. Now, what that does, and the words are bad enough, but the reality is terrifying. This triggers the executive order I referred to earlier, Executive Order 12333, which allows virtually any form of conduct, any activity, to be undertaken as long as it's under this national security cover. So this was the beginning of a national security covered operation against Mr. LaRouche and his colleagues. Why do we have these documents? Not because they gave them to us. They hid these from us. We finally, after years of fighting FOIA litigation cases, were able to peel off small pieces of this grapefruit. There's still a lot left down there. We haven't even got to the seeds yet. We're still working through the pulp. And they fight us at every turn. But we've been able to obtain, through these and through discovery in a number of cases that have been brought, including a case directly against the FBI alleging this misconduct on a past and continuing basis, have been able to obtain certain proofs of the actions that we knew happened but couldn't show you the documents for. Now we have some. The common denominator between all of these cases is twofold. It's, as I said, political targeting, and it's the criminal division of the Justice Department. Can't imagine a more frightening thing than to realize that among the worst abuses of our constitutional rights as a people and for individuals, that they're being, in fact, planned and directed out of the very heart of the agency that's supposed to be protecting those rights. You probably also know from your own experiences with colleagues who have run afoul of the situations that have been discussed that the first place they try is in the press. And then they try you in the courts once they've set the stage, once they've poisoned all the minds in the community against you. Then they haul you into court where you can't get a fair trial because the jurors who are sitting there have been told for days, months, years, or millennia what a bad person you are, what horrible offenses you've committed against the moral or social fabric of the community. Well, that's precisely what happened in the LaRouche case, probably more so than in any other case. Mayor of Washington may come in a close second. But in the LaRouche case, the press began not by accident, because the press, I mean, we all know who owns the press. It's not owned by individuals, and as a matter of fact, there's an awful lot of the ownership of the press which represents certain political and financial interests. All right. So the fact is that beginning in the same period of the 80s, a private financier in New York City named John Train, with reach into the media community by virtue of his social and financial circumstances, convened a group of media types in a salon that he hosted in his apartments to plan a press campaign against LaRouche and his political movement. And their objective was threefold: to tar and feather Lyndon LaRouche and his colleagues as best they could, to advocate and press for prosecutions of any kind in any place, and ultimately to destroy and jail LaRouche and destroy the political movement which he headed. Among those who attended this meeting, and there were several of them that we have evidence of collected over a period of years, and admissions by people under oath, were members of and persons associated with the intelligence community, as well as people with political axes to grind against Mr. LaRouche, such as the Anti-Defamation League of B'nai B'rith, who has for historically done everything it could financially and editorially to label Mr. LaRouche as an anti-Semite, as a fascist, as a racist, as a Hitler, little Hitler, and some of the most scurrilous names we can imagine hurling in another person's face without basis. All of these parties collectively, and unfortunately this is the way these things operate, they don't operate above board, they operate under the table, where you can't see them because they don't flourish well in the light of day, but they grow well in darkness. They get together, and in fact, this has been referred to by others as part of the secret government, the powers that be that operate in conjunction with official agencies but are never seen or heard of. The press published, particularly NBC, the New York Times, the Washington Post, we'll talk about the Los Angeles Times again because they were active, Reader's Digest, and any number of others, began a campaign of the most libelous and vindictive accusations one could imagine. Some of them so vile and unfounded that I have to mention just one of them, for example. NBC, on a national broadcast, accused Lyndon LaRouche of having, and associates, of having plotted and participated in fashions unexplained in the assassination of Olof Palme, the Prime Minister of Sweden. This at a time when he's running for political office in the United States. Of course, once the Berlin Wall came down and the Stasi, the East German intelligence agency, was disassembled, we now learn from a high-ranking Stasi officer who went public, not known to us, but just public in a statement to some magazine in Europe, that this accusation against LaRouche was planted by the Stasi. I mean, so here you go. The intelligence communities, whose hands are they holding? It makes you wonder precisely where this veil of conspiracy and concerted action ends. I want to move on briefly and specifically to the LaRouche cases, which are in fact a series of cases that began in 1984. In 1984, Mr. LaRouche, under his name, sued NBC and the Anti-Defamation League of B'nai B'rith in federal court in Alexandria, Virginia, on libel charges, basically on the basis of the accusations which I've already told you about. We tried that case. NBC lied through their teeth in terms of what information. We had, in fact, had FBI documents that indicated that the NBC reporter had received proprietary and non-public information from 4 agencies of the federal government with reference to Mr. LaRouche. So they give it to, they make the stories up and then they leak them out to people who want to use them against you. We lost the case.
I want to feel what you feel, and maybe everybody else do. I don't, because I don't. I know I'm the only person in this room who don't. Could you tell me, okay, Mr. LaRouche apparently wasn't African American, and apparently wasn't Jewish. I mean, why LaRouche? Who was he? Because I have no idea on what you're basically saying.
The
picture is not clear to me.
I think he will, far more eloquently than I, can probably tell you who he is and what he stands for. He's going to be here.
I could see the government going after, us. But who is Mr. LaRouche and why the government?
For basically the same reasons they're going after you. They don't like what he stands for and they don't like what he's doing.
Yeah, but
he just doesn't happen to be black.
Yeah, but who is he? I mean, tell me about it.
He's a political leader he has, in his own right and through his associates, has taken positions and advocated for political and social positions which are inconsistent with the mainline policies held by and espoused by the federal government, the Democratic and Republican parties. And I couldn't sum up for you in 1 minute. I couldn't do a fair job in telling you who the man is and who he stands for, because he stands for much. and he stands with many, including with you on the issues, and has spoken vigorously on the issues of the targeting of black representatives for prosecution for precisely the reasons you're here today discussing. I don't think he'd argue with that. I think he tries his best to stir up the embers of the dying fire whenever he can. But I mean, I appreciate the honesty of that question, because if you don't know the man,
I like to feel what I'm doing, and I can't feel nothing because nobody want to tell me who was Mr. LaRouche.
well, I've got a bunch of people here who'll be happy to spend some time with you later. I'm sure of that, and I'd be happy to. No, I don't think that would be a fair comparison at all. In any event, we sued NBC in Alexandria, Virginia. As soon as that case was over, NBC Boston, on the very day, as I had finished our presentation and was packing up, go back to Boston, NBC Boston published a so-called investigative series of theirs alleging that certain persons associated with the LaRouche political campaign had made false credit card charges against certain contributors. And they had a couple of contributors who got up and said, you know, I met these people and I gave them $35, and the next thing I knew, there was $100 charged to my credit card. Well, I'll say one thing. Mr. LaRouche is very controversial, and people who contributed to them frequently came under various types of criticism for that contribution. Could be their wife who said, what are you giving $100 away? We need to buy, new shoes for the kids. Or it could be a neighbor or a child, and many times the amounts of money were larger than that, so the reasons for opposing the contribution were even greater. But if you know anything about credit cards, the only way a person can recapture money charged to his credit card, which he has authorized, which has been charged to the account, is to say it was unauthorized. Those are the magic words. If you don't use the magic words, you can't collect the $100. So, in order to reverse a credit card charge, one must say, I never authorized it. Therefore, what you're alleging in that case, although the intent was probably not to make the allegation, but in fact you're alleging that the person did it without your authority, which could be a criminal act. Now, whether or not, in certain circumstances, and I don't think we want to get into that debate or discussion, they started an investigation around this, which they conducted for 2 years. It ultimately culminated in a trial in Boston. Of course, another thing you'll all recognize from your personal experiences is that when they want to charge you when they don't have anything, they charge you with conspiracy, because then they don't have to prove anything. Then they just go around, tell a bunch of stories, and hope that the jury who's poisoned against you is going to link it up somehow and convict you. Right? So the conspiracy is the vehicle, and that's precisely what happened in Boston. LaRouche and his colleagues were charged with conspiracy, with a few other specific charges linked on as an afterthought. We tried the case for 7 months. We weren't even through with the government's case when the case mistried. The reason it mistried is that the jury had been led to believe that the case would have been over long before, which it would have had we been able to concentrate on the evidence, but because of the hearings that the judge was forced to conduct for literally months and months on governmental misconduct, the case dragged on and the jury sat in the jury box. So the jury ultimately got frustrated, much as I imagine they're beginning to feel out in Los Angeles at this moment on a different matter, and wanted to go home, and the case mistried. If you put up the next overlay, this is an article from the Boston Herald that printed that day, and I'm only showing it to you for one reason, not because of the highlight, the LaRouche jury would have voted not guilty, although that's true, and those come out of the words of the jury foreman who was interviewed. But in the first line of text, there are some very important words from the foreman. We would have acquitted everybody at this point, and that's based on prosecution evidence, said Foreman Dashowitz. There was too much question of government misconduct in what was happening to the LaRouche campaign. government misconduct. Very seldom do you get a jury to see it because the government fights you nail and tooth. They lie, they cover up evidence, they, in fact, deny information to their own agents so that the agent won't be in the position to have to intentionally not disclose it. These are common tactics, and that's what happened here. Fortunately, in our case, we were able to show enough of it to the jury so that the jury got the smell. However, the government wasn't about to quit, particularly having taken what was a serious public relations beating at that point in time. So they decided to switch forums, come down to a much more favorable forum, the most favorable forum, the Eastern District of Virginia, the so-called Rocket Docket, the home of almost every government agency and government contractor in the country, with a few other pockets here and there. So they brought the case down there, indicted the case, and brought us to trial. New charges, new defendants. LaRouche was also indicted, so he was one of the few who was also charged the second time, and forced the case from indictment to trial in 28 days. There's a great book that's been, and it's not a novel. It's a factual book. It is the history of the case shown by the documents of the case, and it's called Railroad. And I commend it to your attention. I think copies, if you're interested in reading and see how that system worked in this particular case, it's all there, and it's not somebody else's words. It's the words from the court documents. In any event, LaRouche was convicted, as was all of his co-defendants, again on conspiracy charges. That was the seminal charge. The rest were just tacked on. This case, time it wasn't credit card. It was allegations of wire fraud. The allegation being that loans were taken from contributors without intent to repay, or with reckless disregard of the fact that payment wouldn't take place. Now, these were political loans made in the political context by political people to a political candidate in his political candidacy. Everybody knew that. The government knew they had a problem with that, so what they did was they brought an I missed one piece, which I have to tell you, and I'll do it quickly. Back in Boston, the grand jury that was investigating the case held certain businesses associated with Mr. LaRouche in contempt of court for not producing documents which were under subpoena, which were being fought during a period of time based on various privacy grounds. $20 million worth of contempt sanctions were imposed. The government then sought to collect that $20 million by filing an involuntary bankruptcy against these organizations in Alexandria, Virginia, just prior to not just prior, but some point prior to the Alexandria indictments. They also did this ex parte. They were the only creditor in violation of federal law. But by virtue of their ex parte petition to the judge, we were able to effect the closing of these four businesses, all who engaged in First Amendment advocacy and publication. These businesses were closed. They were seized by federal marshals. They never reopened. The publications never reprinted. The $20 million the government sought was a ruse. In fact, what they intended to do and what they did do was close the conspiracy that they alleged in the Alexandria indictments on the very day that they filed the bankruptcy. The point of the bankruptcy being that from the moment a bankruptcy is filed, an order issues that no debts may be paid without permission of the, I'm sure I'm going beyond the 15 minutes, and I'm feeling a little bit guilty, but no one can pay any debts without order of the court. So it was physically impossible for any debts to be repaid after that, thereby creating a pool of persons who were owed money who couldn't be repaid. They got 5 or 6 of these people to come forward and say, I was promised repayment and didn't get it, and that was the basis for the conviction for loan fraud. In any event, I want to say that we have fought as vigorously as anyone can through the appeals process without success, through the mandamus process, 2255s in federal court, and are now at a stage where Ramsey Clark, who has been with me, former Attorney General of the United States, who has been with me on all of the appeals, he joined the effort just after the sentencing of Mr. LaRouche and his colleagues in 1990. Recently, he wrote a letter to the Attorney General asking for a departmental review of the LaRouche case, and I'd like to read you some portions of his letter. He'll be here tomorrow to speak to you personally, but I'd like to leave you with the following words of Ramsey Clark. Dear Attorney General Reno, I've been an attorney in this case since shortly after the defendants were sentenced in January 1990 and appeared as counsel on appeal and on the subsequent motions and appeals in proceedings under 28 U.S. Code Section 2255 and Federal Rules Criminal Procedure Rule 33. I bring this matter to you directly because I believe it involves a broader range of deliberate and systematic misconduct and abuse of power over a longer period of time in an effort to destroy a political movement and leader than any other federal prosecution in my time or to my knowledge. 3 courts have now condemned the department's conduct in this prosecutorial campaign. The result has been a tragic miscarriage of justice, which at this time can only be corrected by an objective review and courageous action by the Department of Justice. The three rulings of the courts that he's referring to were the ruling of the bankruptcy court, which after 2 years of hearings and review dismissed the bankruptcy, and in its ruling dismissing the bankruptcy found that the government had acted in bad faith and had committed a constructive fraud upon the court. That was number 1. Number 2 was the judge, actually it happened in a different order. The first one was Judge Keaton, the judge in Boston, who found that the government had engaged in systematic and institutional misconduct in withholding evidence, exculpatory evidence from the defense during the trial.
Did he use that language?
Yes, he did, and I'll show you, I've got his decision right here. I'll be happy to show it to you. Number 3 was more recent, and it bears on a subsequent series of cases. Not only was Mr. LaRouche tried and others in federal court, but a number of his colleagues were tried in the state courts of New York and in Virginia as part of this joint federal task force. And the Virginia defendants are at this moment sitting in Virginia penal institutions with draconian sentences of up to in excess of 80 years in prison.
How many people?
6 or 7. 5 at the moment. Five still in custody. Now, the judge who sat on the New York cases in just recently, in reviewing motions brought alleging Brady and Rosario violations. These are essentially, Brady is the obligation to turn over any information which either is or might be exculpatory, and Rosario is a parallel rule under New York state law. Found as follows. I just read a portion of his ruling. All of the foregoing circumstances suggest a studied and calculated effort to use against the defendants enormous amounts of information that the Virginia (brackets federal) prosecutor made available to the New York Attorney General without the onus of revealing any of the exculpatory or other pertinent information that a New York prosecutor has an obligation to locate and produce for the defendants. These circumstances raise an inference of a conspiracy to lay low these defendants at any cost, both here and in Virginia.
And denied
It's a
relief.
New York State judge.
And what relief was
There are orders of new trials
Okay.
granted as a result of the action. I've taken more of your time than I should have, not as much as I'd like to, but there's others who have more to say. I give you, I guess, Mr. LaRouche at this point, and I thank you very much for hearing me.